name's Kate Clark. I'm the legal director of Clark Associates Mediation Services and also a very small niche law firm called ACM Legal. Today, I'm here to talk to you about the importance of intake sessions, and it's an area that I'm really, really passionate about in mediation. I've prepared a little handout which is available for each of you to print or save to your computer. The lovely Rowanna has just added that to the chat box. So if you get sick of looking at me during this webinar, you can also have a look at that webinar document as well. So intake sessions are something that I think a lot of mediators either neglect to do or they neglect to do them well. So I'm really here today to convince all of you that you need to start putting a huge amount of effort into your intake sessions. We do have quite a few mediators here today and conciliators. So I'm keen to know whether you do intake sessions. If you feel free sharing that information in the chat box. I know that a lot of our government mediation services do offer really thorough intake sessions, and that's really fantastic. Private mediators, I think, throughout Australia need to really understand that this is a mandatory step, even if it's not required. Although under really our standards and our regulations, intake sessions are required. I think people often, regard intake sessions as something that can happen on the day of mediation, but I think that that's fraught with danger. If we take, for example, family law mediation, so a parenting matter by way of example, if you have two parents that are in conflict, arrive on the day of mediation, and you as the mediator are then conducting your intake sessions with each of those parties, you've lost a great opportunity in many, many respects, but you've also created a set of circumstances that could potentially be harmful or dangerous for people. One of the most essential parts of intake, of course, is to screen matters for suitability. So if a matter is deemed unsuitable and you're conducting this intake session on the day of mediation, what are you then going to do? You've already potentially exposed people to an unsafe situation. And when I'm talking about safety today, I'm not only talking about physical safety, I'm talking about emotional and psychological safety as well. So if you've, had these people turn up for your day of mediation and you're running your intake sessions on the day, and you as a mediator make a decision there and then that the matter is in fact potentially unsuitable for mediation, are you then going to send people away, or will that create a further harmful situation for people? There's a huge amount of energy that goes into people investing into a process of mediation. Not only the time and effort of getting there, but also the investment, sometimes financially, if they're using a private mediator. I'm a parent of young children, and I put myself into the shoes of parties that are in conflict. They may have had to have organised babysitting, or somebody to drop their children at school, or somebody to collect their children from school. That might have taken weeks of planning. They might have a child who is neurodiverse or has some sort of, additional needs, and they had to actually practice getting ready for the process of mediation. If you then on the day of mediation say to people, this is unsuitable, we can't go ahead today, imagine the harm that you could cause those people after all that investment of time and resources, even in getting there on the day, not to mention the huge amount of anxiety that they might be feeling in the lead up to the process. So for that reason, I really, really recommend that intakes must occur weeks before a mediation. And to be honest, at Clark Associates, our process actually is that in all of our documentation, we require an intake session to happen before we even confirm a mediation date is going to occur. Lawyers like to lock you in the other way. They like to lock in the mediation date, and they consider everything else to be, unnecessary sometimes. But really, the mediation date is being held tentatively, and we need to actually check first whether that matter is suitable for mediation or not. So at Clark Associates, our process is intake sessions are confirmed and they're confidential one-on-one sessions with each party. And then if we make a decision that in fact the mediation is suitable, we go ahead and confirm that mediation date and the arrangements with people by way of letter. So as well as being a screening tool, which is fundamentally important to occur weeks ahead of a mediation for the reasons we already spoke about, Intakes offer so many other advantages. And I think for me, one of the major advantages of intake sessions is rapport building and building the trust of people who are investing their time and resources into this process. Now, I wanted to give you an excellent example of a situation that I had last week. We have here at our offices a really nice, comfortable space for people to come and have their mediations. And when people are going to have their mediation in person, or they're thinking they might have their mediation in person, we encourage them to do their intake session in person as well, for a few reasons. At Clark Associates, we are very trauma informed in all of our practices. So we like to ensure that people actually practice coming to our office, figuring out where to park, figuring out how they're going to get up to our office. What does the office look like? What do we look like? What does that space feel like for them? Even removing the ambiguity around all of those layers helps reduce anxiety for people. This intake session example that I want to give you from last week, a female client attended here at our office. Her lawyer had been telling her that it's highly unusual for intake sessions to occur without lawyers being present. Her lawyer also told her that she shouldn't have any direct contact with Clark and Associates, that all of the contact should only be through the lawyer. For whatever reason, this lawyer had really created this guard position around his client. And I think that that all came from a place where he felt that his client was very vulnerable. But, through some telephone conversations, we really encouraged that lawyer to open their mind to this process and to trust in us as a service, to ensure that we could also provide some support, some appropriate support to the client. And so he agreed, and his client came along here for an intake session. She brought with her a person that we weren't expecting, a support person. And we do invite people to bring support people, but we ask that they let us know who those people are. Because, of course, we then have another layer of protection, which is a confidentiality agreement process that all people attending must sign, not only for the confidentiality of the person that they're attending as a support for, but also for the process itself and for other people who have matters that are being discussed, or even for children who are having, their private lives discussed with people. So this surprise support person came along, and the atmosphere in our waiting room was quite unusually intense when I went along to meet this person. And I said to her, "Thanks so much for coming today. Hello, who is this person that you've brought with you?" Introduced myself to them, gently explained that we have a confidentiality requirement, that we needed some names and details for a confidentiality agreement. And we went through that process. But the response that I got was quite aggressive from this client. And I found that to be a little bit unusual at first. But I asked myself, what's the emotion behind the aggression? And I suspected that it was probably anxiety and fear, and I was correct. She had her guard up. She felt very defensive. She was very worried and very anxious about this whole process of mediation. So I gently introduced her to the process, and I asked her if she would feel comfortable just coming into a room with me to talk while we sorted out the confidentiality agreement with the other person. And she agreed to do that. And I said to her simply, "What was it like for you to come here today?" And she started to cry, and she said, "Awful. It was awful coming here today. I'm so anxious. I'm so stressed. I don't know what any of this process is about. I'm so worried about this whole legal process that I'm involved in at the moment. I haven't slept in weeks. I'm really anxious about everything. I've been through hell and back. I'm really worried about everything." And just simply listening to her and hearing her about how anxious she even felt about turning up shifted her immediately. And she started to develop some trust, some new trust in me, that I was paying attention to how she was. Fast forward to the end of the intake session, I said to her, how are you feeling about the mediation now? And she said, "I'm actually feeling really good about it. I'm feeling like you've really understood the issues that are important for me, that I've had an opportunity to already tell you about everything. I know what it's all going to look like on the day, and I've made some decisions that I feel really comfortable about in terms of process. And I really now feel like I can come along to that mediation and participate. She didn't use the word participate. I'm saying that word, participate in a more, genuine fashion. And that's one of the major benefits of intakes. It's not necessarily just about gathering up all of the information that you as the mediator feel that you need to have to understand the dispute and the conflict. It's actually even about preparing people and getting them to a state of readiness for this process, as well as gaining a commitment from them to participate. So part of it is about just easing people into something, reducing their anxiety, taking away ambiguity about what the process itself might look like. Another thing I want to draw everyone's attention to is some people have been through some really negative experiences with other mediations before, or they've heard about other experiences that people have been to, and they're really worried that it will be the same for them. Or they associate similar types of processes with mediation. For example, court or counseling, those professional sort of environments, they all look the same for some people. And if they have had negative experiences in either a prior mediation or one of those other professional services that they deem as being connected before, that can really create a huge amount of anxiety for people as well. So another simple question that I encourage everybody to ask at the beginning of an intake is, have you ever been to a mediation before? And then a follow-up question is, what was that like for you, in a very, very open-ended way? Or if they say, no, I have not been to a mediation, ask them simply, what does mediation look like for you? What do you understand about the mediation process? And hear them out. And check to see whether there are some assumptions or wrong information in there that you should be correcting. I can't tell you how common it is for people to say to me, yes, I have been through a mediation process before and it was awful. And unfortunately, we have a really hard job then of rebuilding trust and rapport with people who are at a very, very low end of trust and rapport with professionals in our area of work. So not only asking what was that like, but then asking them what was it about that process that was difficult or not okay for them, and learning about that. Another example, I had an intake session with a person who has post-traumatic stress disorder. They actually said to me quite quickly, can you tell me your qualifications? And I said, yes. And I always do at the beginning of every intake, give a bit of an introduction to who I am and really my philosophy of practice as well, to introduce them a little bit to my style. So I went through my qualifications and they said, I need to stop you right there. Are you a lawyer as well as a mediator? And I said, yes, I am a lawyer. And they said, that's a problem for me. And I said, oh, tell me about why that is a problem for you. And they said, I had this terrible situation where this lawyer did this and they did that and they did this and they did that. And I listened and listened and listened to all of the information. And I said to them, geez, I can see that has really impacted you. So some validation of emotion. And they said, yeah, I've never gotten over it. I'm really anxious about being around people in that area of the profession for all of these reasons. And again, just acknowledging and validating those emotions behind that fear, that anxiety. I didn't have to defend the previous person. In fact, I wasn't going to. Some of what they did was pretty ordinary. The lawyer that they were talking about, that they had interactions with, it's not my job to even promise that I won't necessarily do the same things, but just reassuring them through listening and validation of emotion is enough to help people see already that I'm going to be different to the last person that they experienced. So I really encourage all of you to do the same thing. Just these really simple questions. How did you go getting here today? How are you feeling about the mediation? How are you feeling about today's intake? Did you get any sleep last night? Do you have any concerns about the process? Have you been to a mediation before? If you have, what was that like? How are you feeling about this process, given that you had some difficult times last time? This is an opportunity in and of itself to build rapport and trust. But then there's so much more to building rapport and trust. When it comes to rapport, I would really suggest to everybody that one of the most important things is everything you say you're going to do. If you don't do the things that you say you're going to do, you'll have no rapport and trust with people. So be really careful to never overpromise and underdeliver. If you say you're going to get back to them with information, get back to them with information. If you say that you will ensure that they don't see the other party, ensure that they don't see the other party. If you can't promise those things, don't promise them, because you'll lose all rapport and trust instantaneously, which will be really detrimental to your mediation process. There are other aspects of rapport building. And really, I would suggest that the most important thing you do in the beginning of any intake session is just listen to people. But, really pay attention to how people are. Sometimes people don't feel comfortable coming in and starting to talk straight away. If you notice that, then perhaps you point that out and say, would it be all right with you if I introduce myself, my qualifications, tell you a little bit about the process ahead, and then we can come to you and hear a little bit of information from you? They might say, yes, that would suit me. But again, ask them the question, invite them to participate in the process. Show them that actually you're collaborating with them, which feels very comforting and reassuring for people. If you're noticing that they seem to have a lot that they want to tell you, let them tell you. Let them talk. Let them get those things off their chest. They're important to them. They won't be able to concentrate and focus on other things until you allow them to purge some of that information. But of course, there comes a time where you need to give people information as well. So let them purge to an extent and then say to them, look, I can see that there's so much more you want to say about that. Would it be all right if we pause for a moment? I need to just talk to you about some of the structural elements of mediation or our conversation here today at intake. And then we're going to come back to those things that you were just talking about. Ask their permission, seek their permission in respect of what you're doing throughout the process. Again, that feels very reassuring for people. As well as rapport building, we really need to be talking to people about safety. And safety is something, again, that I think a lot of mediators neglect to pay enough attention to. So as well as conducting mediations in family law, I conduct mediations in an area of work called restorative justice mediation. And safety is at the forefront of my mind in every single mediation, even commercial mediations. And I think it's as a result of my work that I do in restorative justice. I can't emphasize enough how important it is to really talk with people about safety, and every person. Don't make any assumptions, for example, that you shouldn't be talking about safety to the person who's either the alleged perpetrator of violence or is confirmed as the perpetrator of violence. There's elements of safety that you need to talk about with those people as well. So safety is something that should be discussed with each and every individual. For me, safety is a massive priority across all matters, as I said before. And I want to talk with you about how I discuss safety. So, of course, in family law matters, I find a way of actually asking people about whether or not domestic or family violence has featured in their matters. In restorative justice matters, I talk with them about how they're feeling about the mediation. And I also ask them a number of prompting type questions to get into a conversation about safety. And then I actually very specifically introduce people to the topic of safety. And I say to them, it's really important in this process of mediation that we together collaborate on how this process will be as safe for everyone as possible. And I explain that when I'm talking about safety, I'm not just talking about physical safety, I'm talking about emotional and psychological safety as well. And I say to them, can you just imagine right now that, we're going to be starting the mediation process? What would feel safe for you? What would not feel safe for you? And then I ask prompting questions like, how will you get to the mediation? What will it be like at the mediation? How will you get home from the mediation? Now, I think a lot of mediators think, it doesn't matter about safety in my matters because I do a lot of online mediations, for example. Sure, online mediations may feel safer, especially for some matters where there's maybe domestic and family violence involved. But don't be so sure. I mean, in this modern age, even having a mediation in a home environment for a person could be unsafe. What if there are listening devices in that location? What if the other person, perhaps there's a husband and a wife who have separated, Perhaps the husband has installed listening devices in the wife's home. She's participating in the mediation from home. And instead of being a shuttle mediation, he can actually hear everything that she's saying. What if that creates an atmosphere of safety, difficulty for her, or puts her at risk, or puts the children at risk? So you must consider safety at all levels and really pay attention to asking people what safety looks like for them. Don't make any assumptions about that. An example I wanted to share with you recently in a restorative justice mediation that I was facilitating, I had a survivor of rape who I was involved in an intake session with. I was speaking with her about creating a safety plan for the mediation ahead. And I spoke specifically with her about what would feel safe or not feel safe for her. She wanted to meet with the defendant in person. That was of the utmost importance to her. So we spoke about that option. We spoke about a safety plan around that, a very, very detailed safety plan of how she would get to the mediation, what support she needed on the day, how she would have breaks, how I would monitor her levels of distress, how we would ensure that she's emotionally and psychologically safe. We came up with code actions, code words, processes that were in place to ensure her safety. But interestingly, the one thing that she was most anxious about wasn't seeing the defendant. She was actually looking forward to that. And I have to tell you, a lot of people say the exact same thing to me. So be careful not to assume. She was wanting to meet the defendant. She was wanting to be in the same room as the defendant. She was wanting to talk with the defendant, and she felt no concerns whatsoever around her safety, physically, emotionally, psychologically, in being present with the defendant. The thing she was most concerned about was coming into any sort of space where the defendant's legal representative would be, because they had already been through a trial and she had been cross-examined by that defendant's lawyer, and she found that cross-examination to be incredibly traumatizing. So interestingly, the lawyer there was the problem for her. So we created a safety plan around how the lawyer would move in and out of the building and how she would be protected from having any interaction whatsoever. And I can't tell you the amount of detail that I go into about this. Venues hate me. They think I'm so incredibly annoying. I sometimes have people on different levels of buildings. I have people behind a door that has a security fob. I have people who have separate toilets that they use, and people are designated to use one toilet and the other person's designated to use another toilet. If I can't manage that at a venue, I actually tell people when they can have toilet breaks. I walk people to the bathroom, stand outside the bathroom, walk them back to their room, walk the next person to the bathroom, stand outside the bathroom, walk them back to their room. You need to be thinking about safety at all levels and really paying attention to what matters to people. Never assume that you know what feels safe or doesn't feel safe for people. A couple of my little tips about safety. I'd mentioned before code words and code actions. Sometimes people don't feel comfortable having breaks, no matter how many times you offer them a break, or you even specifically say, you know, let's have a break. They don't take breaks. That's because they might be shutting down, dissociating, just having a difficult time, or there could be something else going on for them. So really speak with people around what the plan is going to look like. For code actions, I come up with many, many different tailored approaches with people, but a really good tip might be that if you have somebody that's feeling particularly anxious and they do want to participate in joint sessions with the other party, if they're a female, for example, you could invite them to bring along a lip balm, and that if they need a break and they can't verbalize a break, or they don't want to verbalize a break, they can pick up the lip balm and apply lip balm, which is the code to you that they need to have a break. Now, it's important in those moments that you don't say, oh, I see that Catherine has used her lip balm, so we're going to have a break right now. You've breached the confidentiality of your safety plan, and you've also pointed out that that person's not feeling comfortable, which might not be right for them either. So it's just an indicator for you as the mediator to know, now we need to have a break. And you take that on yourself. I need to have a bathroom break, so we're going to have a break. I direct you to go here and you to go to here. And then you go in and you check in on that person to see how they're going. So all safety plans should be kept individual and confidential. You don't tell the other person about the safety plan, and you must make sure you adhere to the safety plan. I would really strongly recommend that people create a file note on file for each matter when a safety plan is created, and that you pull that safety plan out ahead of the mediation, check that all of those details are still in play, and that you deliver on those throughout the mediation process. I want to now talk about trauma-informed practice a little bit more. I know that I introduced the topic a moment ago, but really trauma-informed practice is another area that I would encourage people to build some skills in respect of. There's fantastic training offered by the Blue Knot Foundation, which I undertake often, and I would really encourage people to immediately leave this webinar and go and book in a session with Blue Knot. They offer many, many different webinars as well as in-person practical presentations and skill-based learning opportunities, which are fantastic. In respect of trauma-informed practice, I think it's really essential that we all understand that probably most of the people that we encounter in our work in mediation have been impacted by some sort of traumatic event. Probably a large percentage of people that we see have either post-traumatic stress disorder or complex trauma. In fact, 1 in every 4 Australians have complex trauma, according to statistics provided by the Blue Knot Foundation. And trauma presents in each individual in a very, very different way. So it's not like there's one particular set of symptoms that we see across all trauma survivors. Roanna has just very helpfully put up the Blue Knot website. Thank you, Roanna. So trauma can present in different ways in many different people. It can look like being withdrawn, self-isolating, using drugs and alcohol to cope. It can look like acts of aggression. It can look like explosiveness. It can look like all sorts of different things in each individual. And sometimes those symptoms can change even within an individual. So please don't think that there's one sort of presentation for trauma. Trauma presents in many, many different ways. But importantly, trauma and managing people who have experienced trauma, the focus really must be on relational improvements. So if we can present in interactions with people that are rapport building, trustworthy, reliant, collaborative, empowering, we are actually helping people recover from trauma, which is a huge additional weight that we carry in this profession, but we must do it with intention. So I really encourage people to pay attention to trauma, learn more about trauma, and learn more about trauma-informed skills in practice. The focus in trauma-informed practice is safety, trustworthiness, choice, collaboration, and empowerment. So as well as doing my work in mediation, I also do some work for the Australian Defence Force in respect of restorative engagement conferences. And each and every one of those people that I interact with have experienced trauma and usually have post-traumatic stress disorder. Trauma-informed practice is so essential. Asking people, is it okay if I shake your hand? Is it okay if I sit here? Where would you like to sit? How are you feeling in this room? Does it feel comfortable with the wall behind you? Do you feel comfortable with the door across from you there? Really pay attention to what feels right for people. And those interactions themselves are not only soothing, but they also help people recover from trauma. And if they feel comfortable with you, if they feel that they can invest trust in you, if they feel that they have rapport with you and that you're paying attention to these things, they'll be able to participate in processes. And they wouldn't otherwise. They would shut down, they would become defensive, or some of their symptoms may become amplified in a mediation. In addition to trauma-informed practice and rapport building and building trust and getting to know people, of course, intakes are essential for gathering information. And probably that's what most people think intake sessions are about, gathering information. I think a lot of courses teach people to do intake sessions with checklists. I love a checklist. I'm a huge fan of checklists, but please go off script. Be a human being. Make sure that people leave an intake session feeling like they know a little bit about who you are, what your style is as a mediator. Make sure that you've created a sensation of humanity in the room for them so that they feel a little bit more comfortable. Checklists are a great tool, but also feel free to just listen. people. And when I say listen, I really mean deep listening, not just tell me about when you got married and tell me about this and tell me about that. How is it that you got to this point in your conflict? Open-ended question. Let them just, spill the beans on the whole thing. And then be prepared not to gather information in a very linear fashion from people. I think one of the greatest skills we have as media, our own, linear version or our own chronological version of the story for ourselves, but people don't deliver information in that way. When people are in a crisis or they're in a difficult time, they're usually incapable of delivering information in a linear fashion. And that's why checklists present a little bit of a hazard in this area of work, because you may either not ask the right questions, or they might not be in a place in their mind where they can give you that information because they're thinking about some other aspect. So be ready to really, pivot in an intake session and gather the information in the way that feels right for people, and follow themes of what they're talking about. And then gather up information about that. And if it's relevant, ask some more prompting questions about that. And then say to them, normalize the process for them. I see that, you're having a difficult time talking about that. Do you want to have a break from talking about that for a moment? Or do you want to come back to it? Or do you want to finish that off right now? Again, asking question process feels very reassuring for people. But again, gathering information is only one aspect of what you're doing. You're also gathering information about their and also their emotional drivers. So when people are talking with you, don't just pay attention to the detail of the things that they're telling you about the conflict. Pay attention to how they're telling you about the conflict. Are they very escalated when they're talking about particular parts, or are they very, down when they're talking about parts? It's an opportunity to learn more about the individuals that you're going to be mediating with us, and gather up from them some essentials in understanding their personalities a little bit more, and also what's meaningful for them, not meaningful for them. What are their core values? Those things can stand out in the way that people describe information, as well as the information that they actually give you. In addition to just asking information about the current conflicts that people are presenting, to you about, ask them about what attempts they've made to resolve the matter before, and get a really good understanding of their other conflict resolution attempts. That's a great learning opportunity for you as a mediator too. What have they done? What worked? What didn't work? A lot of people will say, I don't have a lot of hope that this mediation is going to resolve anything. And I'm sure all of us here have heard that the other person is a narcissist 3,000 times. It's not unusual for people to feel pretty negative about whether a mediation is going to be successful or not. So feel free to also add in a good quality dosage of optimism in an intake session. And one of my favorite lines is simply to say to people, you know what, you've done all those other things before. You haven't done a mediation. You haven't done a mediation that's looked like this. You've not been to intake sessions as thorough as this before. You haven't put this level of preparation in before. All of these things in conflict resolution are massive positives. The fact that you both agreed to come and see me, and that you've agreed to embark in this process and put effort and energy into it, that's a huge, source of optimism that you can take from here today and remind yourself about in the lead up to your mediation. You're already halfway towards an agreement because you've agreed to this whole process that you're both putting effort into. And, the intake session I'm doing here with you today, this thorough process that we're going through, I'm doing that with the other person too. I'm encouraging them to really think about their conflict, and I'm encouraging them to really come along to the process of mediation with a sensation of optimism and level of preparedness that they haven't had before. And that can be really reassuring for people. They think, yes, okay, maybe this does have some sort of prospect. And then when they feel committed to it and they feel invested in it, they put more effort into it. Maybe I will go and do those things that Kate spoke with me about, those homework tasks that she spoke with me about. I'll go and put more time and effort into this because maybe this will resolve our issues. Maybe we won't need to go to court after this if we both put the same level of effort in. So that's something that we can give to people as well in an intake session. Just a wonderful sensation of hope and optimism. The next thing I want to talk with you about, as well as all of those wonderful steps of building rapport, trust, gathering information, trauma-informed practice, focusing on safety, is getting to a stage in the intake session where you really start to build a commitment from people to invest. And this should happen, obviously, towards the end of your intake session. And the other aspect of work that you do at the end is groundwork for reality testing. So those are the next two components I'm going to talk with you about. So let's focus in on commitment to participate well. In my family law mediation work that I do, I've actually created a definition around genuine effort, and I describe that level of genuine effort that's going to be required in the mediation process. And I set ground rules for what the mediation day needs to look like. I talk with people about respectful communication, about participation, about preparedness, the things that they need to bring to mediation, the things that they need to do at mediation to ensure that they are participating well. And then I seek a commitment from each individual that they're going to do those things. And by committing with me one-on-one, they're making that contract with me as the mediator. They're not making that contract with the other party who they probably don't want to build a contract with right now. They're building it with me as an individual. And if they don't do those things at mediation, I remind them that they committed to doing those things in a very gentle, appropriate way. Remember in intake, Bob, we talked about how you were going to give a genuine effort in these ways. You were going to do these things. Right now, I can see you're having a difficult time. Do you need to have a break for 10 minutes? And then we'll come back to this process so that you to do things that you said you were going to do. So I just heard from Vanessa. Okay, go have a break. I understand. Come back and we're going to talk more about these things. Okay, and off Bob goes. And he comes back and he remembers his contract with me as the mediator. He's going to participate well, and he's going to give me information that will help narrow issues down and try and resolve things at mediation. So you can actually define with people how you need them to participate well in your intake. Explain that in detail, almost create like with people, and then gain commitment from them about it. On the day of mediation, in your opening statement with each individual or in a joint session, remind everybody about how they're going to participate well, remind them of their commitment, and seek agreement again that they're going to do those things, and then remind them through the mediation process about that commitment. And you'll be astonished at the results. Most people engage really well because they feel like they have to do that because of the contract that they've created with me as a professional. And if I've done all of the things that I promised I would do, then they feel that they need to reciprocate and do the things that they've promised to do. Now, of course, in participating well, we can never require people to reach an agreement or to sign any documents. That cannot be part of what we're asking people to do, because that's up to them. This process of mediation is self-determining. So if they can't reach an agreement on the day, that's okay. But we need for them to do other things like share information generously to help the other person understand the issues in dispute, listen to information shared by the other person, generate some options to try and resolve things, engage in analysis with me as the mediator about options that are put forward by the other party. These are things that we can gain commitment to. Taking a break if they're feeling as though they're not coping or they're triggered or they're emotionally impacted by what they've heard. That's a contract that you can create with people too. And really emphasize and encourage people to have breaks. Sometimes in mediations, especially in restorative justice mediations, people will have many, many breaks in mediations that I facilitate, and I encourage them to do that. It's amazing what 5 minutes walking around outside can do for a person to help them recover and help them to a process and continue to participate well. So you could even say to people, if you're seeing that they're particularly heightened emotionally, one of the contracts we're going to create is that you take breaks often during the mediation process. And if you don't ask for them, I'm going to ask you to have them. And you're going to go and have that break, Bob. Do you agree to that? Yes, I agree to that, he says, because he knows he does need this help from us as a professional. So create this commitment to participate well. And then the next thing that I want to talk with you about is groundwork for reality testing. Now, you can't do this, in my opinion, at the beginning of an intake session. I'm aware that there are some mediators out there, and their intake session is literally only reality testing. A quick phone call with the parties where you say, now listen here, Bob and Vanessa, you're each going to have to compromise at this mediation. Mediation is all about mutual compromising. And if you don't do that, we're not going to have a successful outcome. And did you know that you're going to spend this much money at court and this much money at court? This is ineffective. You haven't got any rapport with people, any trust with people. You haven't listened to their story. They haven't been heard. They haven't been understood by you. You've wasted this magical opportunity to better understand people and their needs and their goals and help them prepare for their mediation ahead. All that's missed if you do an intake session like that. But you can do that reality testing work at the end of all of the other wonderful things that we've just spoken about. And the way that I introduce reality testing is not in an effort to try and change people's mind about how they think about things, because quite honestly, you can't change people's mind about how they think about things, but to plant a seed that there's a different way of particularly analysing a situation. That's something that we can do for people at the end of an intake session. And if you've built a really good amount of trust and rapport with a person, they're going to be much more receptive to this reality testing from you. If you do this great work of planting the seed at the end of the intake, in my view, that allows them to leave, feel like they practically understand things more, feel more committed to the process, and then they ponder in their own time about some of the things that you've asked them to think about or analyze in a different way. And they have the ability to, go home, do all the things that they need to do, then be in the shower, washing their hair, thinking, Kate said this thing about this. Maybe there is something in that, and ponder again in their own time, as I said. And that feels really comfortable for people rather than the pressure on the day of mediation of being told or being questioned or having somebody say to you, have you thought about how much this is going to cost to go to court? Of course they've thought about that. They think about that all the time. They might not know the exact details of it, but they've thought about it. They don't want to be there. They don't want to go to court. They don't want to spend all of that money on court. They've already thought about those things. People are fairly intelligent and well-informed these days and have Google available to them. But what you want to introduce them to is a different way of thinking about their conflict and analysing that in a different way. Ask open-ended questions. What about this, or what about that? Or what if this situation happens? Is it possible X, Y, and Z? And, very often things are possible. So people can't categorically say yes or no. Just introduce them to this concept of reality testing, and also let them know that at the mediation, part of your role as a mediator isn't just to validate everything that they say or validate all of their emotions, which would feel very comforting for each and individual, that you're mediating with. That's not practical. Part of your role as a mediator is to reality test with people and to encourage them to analyze their dispute or their conflict or their issues in a different way. Because if they do go on to court, they're going to have somebody really analyze with them there in a way that's quite confrontational. So better to do it at mediation in an appropriate professional way and allow people to really contemplate whether there is another way of thinking about things. But doing that without any sensation of pressure or fear-mongering. I think some mediators do really focus on an aspect of creating fear or pressure for people. And it's really important that we always observe that this is the lives of other people. They are the experts in their own life, and they should be making their own decisions about what they feel comfortable with or not. We can't get in their way about that. We can encourage them to think about things from a different perspective or to analyze their circumstances in a different way. But ultimately, what they do with all of that is, of course, up to them. This is a self-determining process, and we must remember that. So that's all of the information that I wanted to share with you about intakes today. Hopefully there was some practical information in there. Really keen to hear any questions, or if someone has an example of a recent scenario that they want to seek some input from me about, I'm happy to hear those as well. Rowanna is managing our chat box, and there is a handout that is available for everybody to download. There is also some training available through Blue Knot Foundation about trauma-informed practice, which I've encouraged everybody to undertake. I see that some other people have said that the Mediation Institute also offers a trauma-informed webinar, and there's a YouTube channel for more information. Those are great resources. Thank you for sharing those. Roanna has just uploaded my handout again, which is just a summary really of my thoughts. But hopefully some practical takeaway messages there for everybody.